welcome to Wiser Pinoy TV. This is your host, James Violon, a history and political science practitioner and a graduating law student. Now, for today, we will be discussing about the Indeterminate Sentence Law, the Act number 4103, as amended on December 5, 1933. The purpose of the law is to uplift and redeem valuable human material and prevent unnecessary and excessive deprivation of personal liberty and economic usefulness. As a rule, it is intended to favor the accused, particularly to shorten his term of imprisonment depending upon his behavior and his physical, mental, and moral record as a prisoner to be determined by the Board of Indeterminate Sentence. Indeterminate sentence is a sentence with a minimum term and a maximum benefit of a guilty person, who is not disqualified, therefore, when the maximum penalty of imprisonment exceeds 1 year. It applies to both violations of the revised penal code and the special penal laws. Now let's discuss the coverage under the revised penal code. The court shall sentence the accused to an indeterminate sentence, the maximum term of which shall be that which, in view of the attending circumstances, could be properly imposed under the code, and the minimum term which shall be within the range of the penalty next lower in degree to that prescribed by the code for the offense. The maximum is the penalty imposed as provided by law. Depending upon the attending circumstances, the minimum is 1 degree next lower to the penalty prescribed for the offense. The latter is determined without considering the attending circumstances to the penalty prescribed and is left to the discretion of the court. Now, let's proceed to the example. Homicide with one mitigating circumstance. The maximum penalty of that, as prescribed by law, is reclusion temporal. Since there is one mitigating and no aggravating, it will be in the minimum of reclusion temporal, minimum period. On the other hand, the minimum is 1 degree next lower to reclusion temporal without considering the mitigating circumstance, and that will be the prisión mayor. The range of prisión mayor will depend upon the discretion of the court. Therefore, the indeterminate penalty is a minimum of prisión mayor, which is within the range fixed by the court, to the maximum of reclusion temporal minimum period. On the other hand, under the special law, the court shall sentence the accused to an indeterminate sentence, the maximum term of which shall not exceed the maximum fixed by said law, and the minimum shall not be less than the minimum term prescribed by the same. For example, if the penalty is 1 year to 5 years, the indeterminate sentence may be 1 year to 3 years or 3 years to 5 years. This act shall not apply to persons who are 1. Convicted of offenses punished with death or life imprisonment. 2. Those convicted of treason, conspiracy, or proposal to commit treason, misprision of treason, rebellion, sedition, or espionage, or piracy. 3rd, those who are habitual delinquents. Recidivists are entitled to an indeterminate sentence. 4th, those who shall have escaped from confinement or evaded sentence. A minor who escaped from confinement in the reformatory is entitled to the benefits of the law because confinement is not considered as imprisonment. 5th, those having been granted conditional pardon by the President shall have violated the terms thereof. Those whose maximum period of imprisonment does not exceed 1 year. Now we have to note, guys, that the application of which is based upon the penalty actually imposed in accordance with law. Next, those already serving final judgment upon the approval of this act on December 5, 1933. Next, those sentenced to the penalty of destierro or suspension. So whenever any prisoner who shall have served the minimum penalty imposed on him, said Board of Indeterminate Sentence may, in its discretion and in accordance with the rules and regulations adopted thereunder, authorize the release of such prisoner on parole. If during the period of surveillance such parolee shall show himself to be a law-abiding citizen and shall not violate any of the laws of the Philippines, the board may issue a final certificate of release in his favor. Whenever any prisoner released on parole shall, during the period of surveillance, violate any of the conditions of his parole, the board may issue an order for his rearrest and shall serve the remaining unexpired portion of the maximum sentence. The application of the indeterminate sentence law is mandatory if imprisonment would exceed 1 year. It would be favorable to the accused. Now let's proceed to the probation law, or the Presidential Decree 968 as amended on July 24, 1976. Probation is a disposition under which a defendant, after conviction and sentence, is released subject to the conditions imposed by court and to the supervision of a probation officer. The purposes of the law are: 1. To promote the correction and rehabilitation by providing the offender with individualized treatment. 2. Provide an opportunity for the reformation of an offender which might be less probable if he were to serve a prison sentence. 3. Prevent the commission of offenses. The trial court may, after it shall have convicted and sentenced a defendant, and upon application by said defendant, within the period for perfecting an appeal, suspend the execution of the sentence and place the defendant on probation. We have to take note in this case, no application for probation shall be entertained or granted if the defendant has perfected an appeal from the judgment of the conviction. In other words, the filing of the application for the probation is considered as a waiver of the right of the accused to appeal. An application for probation shall be filed with the trial court. The filing of the application shall be deemed a waiver of the right to appeal. An order granting or denying probation shall not be appealable. However, an outright denial of the court is a nullity correctable by certiorari. An accused must fall within any of the disqualification in order to be denied probation. The disqualified offenders are the following: 1. Sentenced to serve a maximum term of imprisonment of more than 6 years. So meaning, a penalty of 6 years and 1 day is not entitled to the benefits of the law. In the case of Francisco versus Court of Appeals, the Supreme Court held that in case of one decision imposing multiple prison terms, the totality of the prison terms should not be taken into account for the purposes of determining the eligibility of the accused for the probation. The law uses the word maximum term and not total term. It is enough that each of the prison term does not exceed 6 years. The number of offenses is immaterial for as long as the penalties imposed when taken individually and separately are within the probationable period. Second, convicted of any crime against the national security, such as treason, espionage, piracy, etc., or the public order, such as rebellion, sedition, direct assault, resistance, etc. Third, Those who have been previously convicted by final judgment of an offense punished by imprisonment of not less than 1 month and 1 day and or a fine of not less than 200 pesos. Fourth, those who have been once on probation. Fifth, who are already serving sentence at the time of the effectivity of the decree. Except for the reasons specified by the law, a trial court should not deny a petition for probation, especially when the probation officer has favorably recommended the grant of probation. Even if the time of the conviction the accused was disqualified for probation, but at the time of his application for probation, he is no longer qualified, he is not entitled to probation. The qualification for probation must be determined as of the time the application is filed in court. Supposing an accused was convicted of a crime for which he was sentenced to a maximum sentence of 10 years. While affirming the judgment of conviction, the appellate court reduced the penalty to a maximum of 4 years and 4 months, taking into consideration certain modifying circumstances. The accused now applies for probation. In this case, the accused is not entitled to probation. The law and jurisprudence are to the effect that appeal by the accused from a sentence of conviction forfeits his right to probation. That is under the pronouncement of the case Bernardo versus Balagot. So, we need to take note, guys, that the probationer shall 1. Present himself to the probation officer within 72 hours from the receipt of probation order. 2. Report himself to the probation officer at least once a month during the period of probation. The court, after considering the nature and seriousness of the violations of probation, if any, may issue a warrant for the arrest of the probationer. He is then brought to the court immediately for hearing, which is summary in nature. If violation is established, the court may revoke or continue the probation and modify the conditions thereof. If revoked, the probationer shall be ordered to serve the sentence originally imposed and shall commit the probationer. The order of the court is not appealable. A final discharge of probation shall operate to restore to the probationer all civil rights lost or suspended as a result of conviction and to the full discharge of his liability for any fine imposed. Under the probation law, what is suspended is the execution of the sentence, while under the Presidential Decree 603 as amended, what is suspended is the pronouncement of the sentence upon request of the youthful offender. The suspension of the sentence, however, has no bearing on the civil liability, which is separate and distinct from the criminal action. Here, we have to take note that the provisions of the probation law should be liberally construed in order that the objective should be realized and achieved. In probation also, the imposition of sentence is suspended and likewise its accessory penalties are likewise suspended. An order placing the defendant on probation is not a sentence, but is rather, in effect, a suspension of the imposition of the sentence. It is not a final judgment, but is rather an interlocutory judgment in the nature of a conditional order placing the convicted defendant under the supervision of the court of his reformation. Thank you very much for your time. That is all about the indeterminate sentence law and probation law. I hope that you have learned something in this discussion. Thank you, and do not forget to subscribe, like, share, and comment of this channel. Thank you.